The POPI Act is our first consolidated piece of data protection legislation in South Africa. We've had other disparate pieces of data protection legislation in the past, but it's the first one that really focuses on it. Its primary objective is to address data protection in South Africa, and it's based substantially on legislation from the UK. People should start preparing for it in that it's going to come into effect sometime next year. That's what the information regulator has indicated to us. And from the point in time where it commences or when it begins to become in fully effect, because it's partially in effect, responsible parties or corporates and other individuals, business people, whoever processes personal information will have a period of about 12 months to comply. So from this point in time, we've got somewhere in between, or somewhere in the region of between 18 and 24 months. And the reason why we need to start preparing for it in that is that we're going from an almost zero regulated environment or near unregulated environment to a world-class regulated environment. It is a steep learning curve to understand the Act and the complexities that it brings. It will take time, it'll take cost, it'll take resources, and because of the complexities it introduces, you need to give companies and other businesses need to give themselves enough time to implement the complexities. Between 18 and 24 months, depending on when the Act comes out. At the end of the 24 months, if you do not comply with the Act, you will be exposed to the penalties in terms of the Act, the consequences for non-compliance. There's several ways in which non-compliance of the Act is monitored and facilitated. So the information regulator is a body that's created in terms of the POPI Act, in terms of Chapter 5, Part A. And what it says is that part of the duties of the information regulator is to regulate and monitor compliance with the Act. Okay? So the information regulator has the ability to conduct an investigation on organizations to ensure that they are complying with the Act. That's one of the ways. The other ways is where the person whose personal information is being processed, i.e. myself, yourself, or even other businesses that are in business with other corporates, they can request that the information regulator investigate or themselves enforce their rights in terms of the POPI Act in a court of law. So in other words, if they can show or if they can illustrate a breach or non-compliance with the Act, then what that means is that they are able to unilaterally, without the information regulator or by reporting it to the information regulator, ensure that the relevant investigation and bring those penalties and those consequences to the responsible party in those mechanisms. The importance of it comes into context when we look at the events of the last few weeks. In the last few weeks, we've had the report of arguably the largest data breach in South Africa. By certain accounts, up to 66 million records that have been leaked or been accessed and is accessible on the dark net. Now, what POPI does is that it introduces the actual organizational, or in other words, the policy and technical security measures required to ensure that there is a minimum global world-class level of security in respect of that type of information, and to ensure that you don't go below that, because that is the minimum requirement from a global standard. What that ensures is that where people have or where organizations are processing personal information, that they indeed take the matter and look at it specifically, and that's what the Act requires you to do. So one is the prevalence of hacking, breaching, and accessing of personal information. There's a multi-billion rand, dollar, wherever you go in the world, of exchanging and purchasing personal information, because that leads to identity theft, etc. So that's one of the reasons. The other reason is that in the digital age, in the fourth revolution, as some people are referring to it, a lot of information is now on the net. A lot of our data is on the net. in certain accounts, all the information in the world, on the internet, all the data in the world up and until 2012 doubled between 2012 and 2016. That's the rate at which information is being digitized. We're talking about hospitals, IDs, all your information is out there, right? So that's another reason why it's required. As to why it's taking so long, or why it has taken so long for it to come through, there's several reasons. There have been attempts to deal with data protection in isolated instances, and this has not. It's not an end-to-end solution, so it's not effective for all organizations and all industries like the POPI Act is. So that's the first one. So the steps have been taken. That's the first thing. The second thing is also that there at times that there are various competing interests in that space. One is, for example, digital migration and access to internet or broadband access. So there are competing interests in that space where resources, energy are diverted to those things. So what happens is, obviously, the POPI Act has not been brought in as quick as possible. The other important thing, and sometimes what we don't take into account, is that the Act was signed in 2013, right? And the reason why it hasn't been fully effected, and it's partially in effect, and those are non-consequential in nature. In other words, there's no penalties for non-compliance. But the reason why the reason why there's a time frame between when it was signed and when it's going to come into effect, and this is next year, is that government and many businesses as well need the time to evaluate their organizations to ensure that they understand and are able to implement compliance with the Act. It is a onerous exercise. It is an exercise that requires specific focus, and it requires specific expertise and resources. And that's another reason why, because we need to get familiar with the Act and its obligations.